Capacity to contract. Capacity to contract means the legal ability of a person to enter into a contract. Under the Indian Contract Act, 1872, only persons who are legally competent can make a valid contract. According to Section 11 of the Act, a person is competent to contract if he has attained the age of majority, 18 years, is of sound mind at the time of making the contract, is not disqualified by law. A minor is not competent to contract, and a contract made with a minor is generally void. Similarly, a person of unsound mind or a person disqualified by law cannot enter into a valid contract. Example: an agreement made by a 16-year-old minor to sell property is not enforceable by law. Thus, capacity to contract is an essential element of a valid contract, ensuring that only legally capable persons enter into binding agreements. Case law for capacity to contract. The concept of capacity to contract under the Indian Contract Act, 1872 has been clearly explained through important judicial decisions. The most important and frequently cited case is given below. Mrjsbhatti v. Damodars Ghose, 1903. This is a landmark case on the capacity of a minor to contract. Facts of the case. Damodars Ghose, a minor, mortgaged his property to a moneylender, Mrjsbhatti. At the time of making the contract, the moneylender knew that Damodars was a minor. Issue: whether a contract entered into by a minor is valid and enforceable. Judgment: the Privy Council held that a contract with a minor is absolutely void from the beginning, void ab initio. A minor is not competent to contract under Section 11 of the Indian Contract Act, 1872. Principle laid down: a minor cannot enter into a valid contract. Such a contract is void and cannot be enforced by law. No estoppel can be applied against a minor. Conclusion. In conclusion, the case of Mrjsbhatti v. Damodars Ghose, 1903, clearly established that a minor is not competent to contract under the Indian Contract Act, 1872. Any contract entered into by a minor is void ab initio, meaning it is void from the very beginning and has no legal effect. The court also held that the doctrine of estoppel does not apply against a minor. This landmark judgment protects minors from legal exploitation and is a fundamental authority on capacity to contract, making it highly important for LLB examinations. Capacity to contract, important case laws. Mrjsbhatti v. Damodars Ghose, 1903. This is the leading case on capacity to contract. The court held that a contract made with a minor is void ab initio, meaning void from the beginning. A minor is not competent to contract under the Indian Contract Act, 1872. Such a contract cannot be enforced, and it cannot be ratified even after the minor attains majority. Nash v. Inman, 1908. In this case, a minor purchased fancy clothes. The court held that a minor is liable only for necessaries, and luxury items are not considered necessaries. The supplier must prove that the goods were necessaries and suitable to the minor's condition in life. Leslie, R. Limited. Shiel, 1914. Here, a minor obtained a loan by misrepresenting his age. The court held that money cannot be recovered from a minor, even if he falsely represented himself as a major. The law protects minors, and no action lies against them for repayment. Conclusion. These cases clearly establish that a minor lacks capacity to contract, is liable only for necessaries, and enjoys strong legal protection even in cases of misrepresentation.